Hello, and welcome to part 2 in our series, A Visual Guide to Institutional IP. Institutional innovation is an exciting field to be involved with, but understanding the nuances of how it works can be a heady and complex task. So to make this topic more accessible, we decided to use this tree as a metaphor. We start with key trends that drive IP policy as the roots. These roots feed or inform the trunk, which represents the IP laws and policies on your campus. Of course, the trunk leads to the branches, which represent how IP policy is implemented on your campus, as well as how you educate your campus community about IP policy. The fruits and flowers are the outcomes, those beautiful ideas and products your campus community develops. In this particular video, we're going to discuss law and policies. As with the trunk of a tree, law and policies is the densest and most substantial topic we cover, but we've done our best to keep it as simple as possible and refer you out to additional resources should you need to know more. So let's review the material we'll be covering in this video. First, we will provide a brief overview of IP laws. We will then look at how IP agreements are formed. We will then provide examples of how IP is often created on campuses. Finally, we will use a case study format to examine different IP policy language and how IP disputes are resolved at different institutions. Oh, and of course, before closing, we will point you to additional resources on these topics. There's a lot to cover in this video, so let's get started. Intellectual property laws in the US and around the world grant valuable rights to inventors and authors of creative works like books, music, software, and more. Universities, colleges, hospitals, and other research institutions are hubs of intellectual creation, spending billions of dollars each year on programs generating IP. In most countries, including the US, ownership of intellectual property by default initially belongs to its creator. However, these default rules can be modified by contractual agreements allowing institutions and individuals to customize their IP rights. Let's talk briefly about the history of institutional IP policies. It has always been in an institution's best interest to, at times, assert control over the ideas and works of authorship that it invests in and helps create. In recent decades especially, institutions have become increasingly involved in the management of IP generated on campus. Managing IP has become a large enough responsibility that most research institutions today have a technology transfer or similarly titled office that exists solely to supervise this task. This trend has coincided with the United States passage of the Bayh-Dole Act in 1980 as part of its efforts to stimulate the national research economy. The Bayh-Dole Act, as well as similar legislation in other countries, officially authorizes universities and other research institutions to claim ownership over inventions whose development was sponsored by a federal agency. In return for this federally granted authority, the institution must 1. File for eligible U.S. patents in a timely fashion, 2. Share reasonable IP royalties with the inventors, and 3. Comply with various other procedural requirements. You may be wondering when the formation of one of these IP agreements actually occurs. Well, whether you fully realize it or not, at some point, students, faculty, and other institutional community members all agree to be contractually bound by their institution's intellectual property policy. The context in which this agreement is formed varies depending on the type of party involved. Let's take a look at some of the more common scenarios faculty, students, and staff typically encounter. Faculty members and institutional research employees tend to conduct the most advanced, highly funded operations on campus, and are therefore heavily involved in the generation of IP. Faculty and research employees typically agree to a written clause in their employment contracts, binding them to the applicable parts of the institution's IP policy. In contrast, undergraduates at colleges and universities tend to be enrolled primarily as students. Undergrads typically agree to be bound by their institution's IP policy during the enrollment process by signing a clause in their acceptance letter or other written documentation. However, there are many students who have jobs on campus, and in those cases, students should check their institution's IP policy and employment contracts to see if becoming an employee affects their rights. Graduate students share characteristics of both faculty and undergraduates, functioning as both students and employees in various contexts. Grad students should be aware that they often agree to separate set of IP-related terms within their enrollment documentation, employment contracts, and in other paperwork. Alumni and former employees no longer at an institution are typically no longer bound by its IP policy. However, activities they began while still on or associated with campus may still be subject to the policies in effect at the time. Finally, other institutional employees and community members frequently reach agreements with their institution regarding IP. These agreements can vary greatly in scope depending on the nature of the relationship and are sometimes custom negotiated. Those seeking further clarification on contract formation issues should consult their Technology Transfer Office for additional information. So now that we know how IP agreements are formed, let's talk more about what IP policies actually do. Here's a closer look at the major terms and conditions typically found in an institutional IP policy. While each institution's stance on IP is unique and policies vary, there are a number of industry-standard topics addressed by most, if not all of them. Perhaps the most significant thing these policies do is transfer some or all of a creator's IP ownership rights to the sponsoring institution or other third party. Different parts of the IP policy may apply differently to campus community members depending upon the type of project they're working on. For example, policies relevant to a student working on a capstone project are generally different from the policies that are relevant to a faculty member conducting sponsored research. Policies also frequently handle the ownership of patent-eligible subject matter, for example inventions, differently than copyrightable works of authorship, such as published research papers. Institutions also impose a number of procedural requirements on community members aimed at identifying campus IP and enhancing its commercial potential. For example, inventors of a technology developed using sufficient campus resources are typically required to submit invention disclosure forms notifying the institution that an invention has been discovered. Other procedural obligations often involve confidentiality and non-disclosure restrictions, or may require inventors and authors to assist in the patenting or copyright registration process. Policies also typically determine the sharing of IP-related royalties, distributing such assets between the institution, the creator, the creator's department and/or college, and other affiliated parties. Lastly, it is important to note that IP policies can also affect non-IP rights. For example, the right to incorporate a startup company or to claim a certain amount of startup equity. These ancillary terms can affect a wide range of scenarios and should always be reviewed in advance by those who anticipate involvement in IP creation. Now that we've talked about what these policies actually do, let's look at 4 common examples of how IP is created on institutional campuses. The most clear-cut and closely regulated scenario is when federally funded research leads to the discovery of a new invention. As discussed previously, federal law explicitly authorizes institutions to claim ownership over federally sponsored inventions. In turn, inventors and technology transfer staff are required to work together to patent the invention before the patenting window expires. Because of these regulations, there is significantly less leeway for institutions to customize IP rights when federal money is involved. Sponsored and other formal academic and research programs are another major area where IP is generated. These situations are likely to be addressed explicitly by the institution's IP policies. Without federal sponsorship involved, there is significantly more wiggle room for institutions to customize the flow of rights. In addition to institutional ownership, IP sales and licensing transactions with third parties, such as private industry sponsors, are also not uncommon in this context. Another area where IP often arises is in the context of undergraduate capstones and academic design projects. The IP rights in these scenarios can either be addressed directly by the institution's main policy or handled separately by the particular program's policy. Even when dealing with projects without a formal policy in place, institutions frequently assert ownership over creations developed utilizing more than a certain threshold of campus resources. The last IP creation scenario we'll look at is when IP is informally created on campus, but not as part of a specific program or assignment. Depending on the amount of campus resources at stake and the specific language used in its policy, institutions will also assert ownership over IP generated in this fashion. Anyone who anticipates being involved in the creation of IP on campus should therefore review the fine print of their institution's policy to see just how far it reaches. Let us now turn from discussing general information and scenarios to a more specific analysis of language that actual institutions today are using in their policies. Because many IP creation scenarios cannot be foreseen or specifically addressed by every policy, institutions often utilize different types of catch-all language. This language is designed to cover a broad range of scenarios pertaining to all members of the campus community. It also sets a baseline level of policy strictness, reflecting the institution's overall IP strategy. Since the use of campus resources generates varying degrees of cost to the institution, catch-all language is generally worded in the context of resources used, as in what resources were used when the IP was created and to what degree. Here are some case studies illustrating how variably strict these policies can be. One institution we looked at is a private, medium-sized research and teaching university in the Northeast. This university's IP policy is extremely broad and claims ownership over all inventions and supporting materials whose creation involves any use of its resources. What we'd consider to be a strict, even draconian, baseline policy. The data suggests that although this university managed to succeed in generating some additional licensing revenue, its overall IP output, as measured by invention disclosures and patents filed, was average or below average at best. What does this mean? Well, for starters, it demonstrates that if an institution's IP ownership policy is overly strict or draconian, it is possible that the overall innovation output and IP culture at the institution may be diminished, even if there are modest revenue gains. Other institutions use slightly more specific and consequently less strict language based on the use of campus resources. For example, one large public land-grant university in the Midwest allows all inventors to own their IP unless the invention was 1. Created using significant campus resources, 2. The technology was derived from an existing university-owned technology, or 3. There were faculty co-inventors involved. We would describe this baseline policy as one that is commonly encountered in the industry and therefore intermediate in its strictness. Data shows that this institution generated significant additional licensing revenue and launched more startup companies relative to its peers, suggesting that the additional specificity in its policy may be helping to promote a healthy culture of innovation. Other campuses narrow this language even further, adopting a more reasonable policy based on the use of campus resources. The first of these, Case Study 3, is a public land-grant university in the Mid-Atlantic. It narrows its language to use of university resources or facilities not available to the general public. The second, Case Study 4, is a research university in the Southeast. This policy's catch-all clause also relates to the use of resources, but it only claims ownership over IP when resources that are not available for free to the public are used in more than a purely incidental way. We would consider these last two policies to be progressive in terms of strictness. Institutions such as these appear to be part of an emerging trend in favor of limiting catch-all language in an effort to promote fairness and innovation on campus. Let's switch gears and analyze practices revolving solely around student-created IP. Some institutions relax the strictness of their baseline IP policy with respect to students, thus promoting student IP ownership. Others make little distinction and instead lump students into their general policy. For example, looking back at Case Study 1, we can see that its IP policy explicitly includes students in its strict catch-all language, thereby limiting student ownership of IP. Another institution we looked at has an arguably even stricter IP policy with respect to students. This university, Case Study 5, is a public research institution in the Mid-Atlantic. Its IP policy states, "The university claims ownership and control of the worldwide patent and intellectual property rights which result from activities of its faculty, staff, and students." By widening its policy to encompass all activities of university community members, including students, this policy appears to be suppressing innovation potential by creating a hostile IP environment. This certainly appears to be the case because this institution recently reported IP outputs, consisting of annual licensing income and US patents granted, that fall substantially below institutional averages. Our sixth case study is a public polytechnic university in the Southeast. This school's policy completely exempts all non-sponsored, student-created IP, so long as during its creation the student was not functioning as an employee of the institution. Compared to similar institutions, this university reported an extremely high volume of both patent applications filed and licenses generating more than $1 million, a key indicator of research quality. Our final student IP example is from Case Study 4. In this case, students own their own IP unless they were an employee, performed sponsored research, or made use of significant campus resources. Relative to its peers, this institution excelled in generating a high volume of invention disclosures and startup companies. So while it might be tempting for institutions to try and maximize IP revenue in the form of strict policy, these case studies instead suggest that a less strict policy may in fact enhance the overall innovation output and IP culture on campus. Dispute resolution is another important aspect of an institution's IP policies. In this last section, we're going to discuss two case studies illustrating how different policies address rights disputes between creators of IP and their host institution. Case study number 7 is a private urban university in the Northeast. This institution's policy surprisingly grants the Vice President of Research sole discretion to block an IP creator from receiving royalties if their conduct is judged to have breached the school's IP policies. Vesting this much authority with a single administrator is a non-transparent and potentially unfair process. Without a proper assurance of fair treatment, it is possible that this type of dispute resolution policy may serve to diminish the IP culture at the institution. Case study number 8 is also a private urban university in the Northeast. Its policy states that in the event of an ownership conflict, a panel jointly selected by both the institution and the creator shall be convened to determine facts and help settle the dispute. This type of approach promotes fairness and fosters a positive IP culture at an institution. So this concludes our Law and Policies video, part 2 of 4 in our series, A Visual Guide to Institutional IP. We've shown that laws and policies seriously impact innovation output and IP culture on campus. For additional information, we encourage you to review the case studies we've outlined, along with other visual guides from this series. Key trends that drive IP policy, implementing IP policy and culture on your campus, and educating your campus community about IP. Thanks for watching.